In this video, we'll revisit the Fourth Amendment and talk about whether an officer leaning into your car and talking to you can constitute an illegal search under the Fourth Amendment. In this video, we're dealing with a Ninth Circuit case, United States versus Malik Ngumezi. And here's what happened. We have Malik parked at a gas station, and he's sitting at the driver's seat right behind the steering wheel. The officer arrives to this particular gas station and notices that the vehicle does not have license plates. But there's a bill of sale attached to the passenger side corner of the windshield. Now, sometimes the states provide us those paper plates when you try to register the car, when you first buy it, and sometimes they make you attach a bill of sale to the windshield. Now, there was nothing illegal in this for Malik. He purchased this vehicle, it wasn't a stolen vehicle. But to investigate further, the officer comes up to the passenger side of the vehicle. Now, remember I told you the vehicle is parked against the pump, so there's a little room. So the officer decided to go on the passenger side just because there was more room. But here's the interesting thing that he does. He decides to open the door, lean into the vehicle, and ask Malik for his driver's license. Now, Malik does not have a driver's license. It turns out the driver's license is suspended, so he's not supposed to be driving a vehicle. Now, under the policy of this police department, if the vehicle is driven by somebody who does not have a valid driver's license, their policy tells them to tow the vehicle. So that's exactly what the officer does. He calls for backup and calls a towing company. Now, before they tow the vehicle, they conduct an inventory search of everything inside the vehicle. Now, I have videos on inventory searches, and I will link some of them here above. I encourage you to watch those to understand how inventory searches work.
The bottom line is, we all have things that is very important to us that we don't want other people to touch. How would you feel if someone went through your stuff?
When they search the vehicle, they find a firearm. So Malik is charged with felon in possession because he had prior criminal history and he was not allowed to have firearms. When he was at the lower court, his attorney argued that the officer did not have reasonable suspicion to go into the vehicle. Why? Because even though there might have been reasonable suspicion in the beginning, thinking that this vehicle might be stolen, when he approached the vehicle, he saw that there is a bill of sale attached to the windshield. So his reasonable suspicion should have been dispelled by the sight of bill of sale. But the lower court said that there was no testimony whether the officer actually saw that piece of paper before he opened the door. Because of that, his motion to suppress the firearm was denied. Now, when we get to the Ninth Circuit, Malik raises a different issue. He says that we need to take a step back, and he says that opening the door and leading into the vehicle in itself constitutes an illegal search, something that's a violation of the Fourth Amendment. Now, here's a lesson to everyone who doesn't practice and a reminder to those people who are attorneys and actively practice in criminal law.
Please don't brag. Only fools brag. Bragging just shows you can shoot off your big mouth. If you're great, people will know it. You don't have to tell them anything, just like I don't have to tell you. Understand?
Don't forget to object and raise issues. In this situation, Malik's attorney buried this argument in the footnotes. So technically he did not preserve this argument for appeal. So the Ninth Circuit says that they can just not rule on it. But the government decided to forfeit the claim of forfeiture, meaning that they did not say to the Ninth Circuit in their brief that this issue is closed and foreclosed and we should not be even talking about it. Instead, they forfeited, and they addressed it on the merits. And because they did, the Ninth Circuit moves on and talks about this issue. Now, before we explain how the Ninth Circuit resolves this issue, here's a reminder. The Fourth Amendment protects you against unreasonable searches and seizures. What does that mean? It means that officers need to have a warrant before they search you or your property. Now, it wouldn't be the law without exceptions. Of course, there are exceptions to the rule. The first issue that the government raises is that intrusion into space doesn't always constitute a search. But the Ninth Circuit says that it does. Of course, anytime officers go into space, go into a room, go inside a container, open up containers, that constitutes a search. Now then we're talking about diminished expectation of privacy. I have other videos dealing with expectation of privacy, and I'll be honest with you, I have many of them on my channel, and I encourage you to watch as many as you can to understand what expectation of privacy means. Sometimes you do have expectation of privacy, sometimes you don't. In this situation, the government says that Malik has a diminished expectation of privacy in his automobile. Really, what they're raising is called an automobile exception. Sometimes officers are allowed to search automobiles just because we have less interest in our automobiles compared, for example, to our homes. Why? Because we drive vehicles on open public roads. And because of that, other people can see, let's say, license plates, people can look inside windows of the vehicle. You're on a public street. Now, that expectation of privacy might change if your vehicle is parked, let's say, on a private driveway or on a private farm. That might change. But in this situation, he's parked at a gas station. So the government says that Malik had a diminished expectation of privacy. Now, you also need to look at the case Jones that dealt with a GPS tracker where the officers attached the tracker on the bottom of the vehicle to track a person, and whether that constituted a search in itself by placing it on the outside of the vehicle. I have that video, I've discussed it before, and again, I ask you to click the link above and watch it to understand how that worked. Now, if we're dealing with automobile exceptions, you still need to have probable cause that something illegal is in the vehicle. Now, in this situation, the crime that we're thinking about is driving without a license or a potentially illegal vehicle. What could the officer possibly find or have probable cause to think that the evidence of the crime is inside the vehicle for these two crimes? Well, of course, there wouldn't be the driver's license inside the vehicle because we know Malik has a suspended license. He doesn't have it. So what could you possibly be looking for? So in this situation, the Ninth Circuit said that automobile exception does not apply. And at the end of the day, the Ninth Circuit says that there can be a bright line rule. Anytime an officer opens the door and enters into space, a passenger compartment of the vehicle, that will constitute a search under the Fourth Amendment. And because it's a search, and because there's no exceptions to this particular search, the automobile exception does not apply, the firearm that was found in the vehicle should have been suppressed at the lower court, says the Ninth Circuit. Meaning that this firearm could not have been used at trial against Malik. Why? Because we have what's called an exclusionary rule. Any evidence found after an illegal search should be excluded from trial under the doctrine called fruits of the poisonous tree. There's a couple of exceptions to exclusionary rule. One of them is that the connection between the police conduct, or in this situation, misconduct, and the evidence found, the firearm, is too remote. It's called attenuation doctrine. Now, I have other videos about attenuation doctrine. I encourage you to watch those. But in this situation, interestingly enough, the government does not even raise it. So the Ninth Circuit doesn't rule on it. It says it doesn't apply. The second exception is inevitable discovery, meaning that at the end of the day, the officers would have found that evidence some other way, regardless of the illegal search. Again, the government does not even argue this. Instead, they focus on this third one, saying that if we suppress the firearm, there is no crime, meaning that a guilty person will go free. Well, the Ninth Circuit doesn't buy it. Of course the guilty person will go free. That's the whole point of exclusionary rule. That's what we do in these situations. It's all about letting one person go, but making a precedent for the police moving forward, meaning that innocent people like you watching and I can drive freely on the street without being pulled over and without being searched illegally.
Some people expect a free ride through life, cruising by on good looks and luck. Let me tell you something right now. It don't work that way.
If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.